This is Oliver Ellsworth, the third Supreme Court Justice of the United States. Oliver Ellsworth was born on April 29, 1745, in Windsor, Connecticut. His father was Captain David Ellsworth, and his mother was Jemima Leavitt Ellsworth. He grew up on a farm with his brother Martin Ellsworth. Few information on his childhood is known, besides the fact that his father wanted him in the ministry. When Ellsworth was a teenager, he was shipped off to boarding school that was ran by Minister Joseph Bellamy. Ellsworth entered Yale University at the age of 17, but soon left due to disciplinary issues. His parents requested he be enrolled at the College of New Jersey, which is now known as Princeton University. Ellsworth pursued his study of theology and earned his Bachelor of Arts degree in 2 years. Soon, he went into law. After 4 years in 1771, he gained admission to practice law at the age of 27. He did not have enough money to own a horse and had to walk 20 miles when his presence was called for at court. In 1772, he married a 16-year-old Abigail Walcott. She came from a wealthy, influential Connecticut family from East Windsor. The two had 9 children who would later go on to do amazing things. Due to disobeying his father's wishes of him being part of the ministry, he no longer gave his son financial support. Young Ellsworth had difficulty providing for his family while at the same time repaying his college debts. For additional help, he worked as a farmer and a woodcutter. He served in the U.S. Senate from the state of Connecticut from March 1789 to March 1796. Oliver Ellsworth was appointed by George Washington to be the third Chief Justice of the Supreme Court on March 3, 1796. In addition, he served as Commissioner to France in 1799 to 1800. There were 4 cases in his career to make an imprint. The first was in 1796 in the Hilton v. United States case, in which the court stated a yearly tax on carriages that did not violate the articles. The conclusion was carriage tax was not a direct tax requiring apportionment. This was significant because it was the first case by the Supreme Court to use judicial review. Hollingsworth v. Virginia was in 1798 and confirmed that a president does not possess the power to amend the Constitution or any amendments. Calder v. Bull in 1798 came to 4 conclusions. The first was that ex post facto was applied to criminal cases and not civil. Second, the Supreme Court had no power to conclude if a state legislature violated a state's constitution. Third, no man should be compelled to do what the laws do not require, nor to refrain from acts which the laws permit. Finally, the court decided that any state legislative act is not a violation of the ex post facto clause. The last notable case was New York v. Connecticut in 1799 that came from a land dispute. It was the first time they exercised original jurisdiction under Article 2. Although Ellsworth had many achievements, he is not recognized as being noteworthy. He was a great lawyer and advocate, but not an exceptional jurist. In his short 3.5 years, his mark was not impressive to many. However, he did introduce the system of per curiam decisions, which allowed a majority and minority opinion to be written rather than each justice writing their individual opinion. His system was even carried out by the remarkable John Marshall. Oliver Ellsworth served on the Committee of 5 who prepared the first draft of the Constitution. However, he left the convention before ever signing it. Instead, he went on to write letters of a handholder. The town Ellsworth in Maine is named in his honor. Also, he was not Washington's first nor second, but third choice to be Chief Justice. First choice John Rutledge was rejected by the Senate. Second nominee William Cushing, a senior associate judge, declined office. In 1801, he retired and resided in Windsor, Connecticut. Ellsworth passed away on November 26, 1807, and was buried at the First Church of Windsor.
Dred Scott v. Sandford case. Who was involved? Dred Scott, black slave born in Virginia during the 1800s. Harriet Robinson, black slave from Virginia. She married Dred, and she was 15 years younger than him. Eliza and Lizzie Scott, Dred and Harriet's daughters, both born in free states. Dr. John Emerson, owner of Dred Scott and his family. He was an assistant surgeon in the Army and died in 1837. Irene Emerson, wife of John. Major Lawrence, owner of Harriet. The Blow family, Peter, sold Dred Scott to John. Elizabeth was his wife, and they had 8 kids, 2 of those being Taylor and William. Roger B. Taney, Chief Justice, and he supported slavery. James Buchanan, president from 1857 to 1861. He was pro-slavery. John Sandford, owner of Dred's family. He was the brother of Miss Emerson, and he was from New York. Samuel Nelson argued that the case should be state, not federal. In 1818, Dred Scott moved to Alabama to live with Peter and Elizabeth Blow and their 6 children. He worked at a cottage inn for 12 years, while Elizabeth and Peter had 2 more children. In 1830, Peter died, and Dred Scott was sold to John Emerson, where he was to be a servant. This was much different than working at a cottage inn. In December 1833, they moved to Missouri, then to Illinois, which was a free territory. Then in May 1836, Scott got transferred to Mississippi and Wisconsin, which is now Minnesota. There he met Harriet Robinson, and they got married in 1836. Major Lawrence was leaving in the winter, so he sold Harriet to John. In April 1836, Harriet had her first daughter, Eliza, in a free state. In 1843, John died, and the Scotts were not left in the will, but Irene figured they were her territory. On April 8, 1846, the Scott versus Emerson court case happened in Circuit Court of St. Louis, where they petitioned for freedom. Francis Murdoch was their lawyer. The Blow family, specifically Harriet and Taylor, helped them because they were anti-slavery. They were not granted their freedom, but Miss Emerson transferred them over to her brother John Sandford. The Supreme Court case was brought up in 1846. A decision was made on March 6, 1857, 2 days after Butchman became president. The case was settled after 11 years of litigation. The society was not united because the North and South were on different ends. The North was anti-slavery and the South was pro-slavery. Butchman wanted this case handled because he didn't like the way it was tearing the nation apart. The case Dred versus Emerson was first a state case in St. Louis. Then it became Dred versus Sandford, and the case originated in the Supreme Court in Missouri. Dred and his family wanted to petition for their rights because they were illegally held as slaves in 2 free territories. The Blow family is said to have helped them with this case. Dred Scott went to federal court to sue because he was brought to Illinois, which was a free state, according to the Northwest Ordinance of 1787, and Wisconsin, which was a free state, according to the Missouri Compromise of 1820. Dred brought up that through the Missouri Compromise, him being in those territories should grant him right for citizenship. He also made the statement, "Once free, always free," and he was free in those states. James Butchman was talking to the Supreme Court Justice Robert Cooper Greer because they wanted someone from the North to side with the South and majority of the court, so it wouldn't look biased. He thought that the case was ripping the country apart and wanted to settle it. There were 3 major questions being asked by Roger Taney, Chief Justice. First, does Dred Scott have a right to bring this up in federal court? Second, does Congress have the ability to regulate slavery in slave territories? Third, is Dred Scott free? This was a violation of the Missouri Compromise and the Constitution, but then it turned into a violation of the Constitution for Sandford and how he owns property. Answering the 3 questions, the Supreme Court decided, first, Dred Scott was not a citizen because he was property according to the 5th Amendment of the Declaration of Independence, so therefore he couldn't bring this case to trial. The Constitution only gives federal rights to citizens. They stated that because the Declaration says you have a right to your property, the property of a slave could not be taken away from you. Neither slave nor their descendants, free or not, were citizens. Second, the ability to regulate states due to the Missouri Compromise was unconstitutional. This was the second time they had ever said that a federal act was unconstitutional. Third, Dred Scott was determined not free by a 7-2 vote. They said the ruling of the Missouri court stands. They said that blacks, free or slave, were not citizens and cannot be granted citizen rights. The Supreme Court said that slavery is property. This means that if a slave was like a handbag, it didn't matter where you took the handbag, it would still be theirs. Butchman was seen whispering in Rogers' ear on March 4th, thinking that they settled the Civil War debut, but they did the exact opposite. This split the United States in 2. Southerners began to think that since slaves are territory, they could take them anywhere like New York, and they would stay their slaves. This scared the Northerners. This decision allowed slavery to spread west. It strengthened abolitionists because they saw the decision as unfair. It helped form the new Republicans Party. They stated that blacks should be citizens since they could vote in 10 out of the 13 states. 2 days later, the nation entered into the final phase leading up to the Civil War. Taylor Blow then bought Scott's family and set them free in St. Louis.